Good evening, everyone. Tonight, we're going to have another section of the Legal Hour program. As I said for my intro, I'm going to look at personal injury. I'm going to look at personal injury law tonight. Specifically, when we talk about personal injury, we are looking at accident where people are involved in motor accident at the workplace, accident at public places, at the shop floor, accidents at certain premises that are controlled by licensees. But it's quite a broad area, so tonight I'm just looking at that specific area covering the workplace. That's what I'll be looking at tonight. So I'm going to take my time to take viewers through how accidents occur at the workplace, and if they do occur, what they need to prove in order to be able to be eligible to get financial compensation for their injuries and other benefits that they are more likely to be entitled to. And beyond that, I also look at the time limits that people are required to submit those claims, because otherwise they will become extant. So tonight I'm going to look at all these areas of the law, specifically accident at the workplace. So I want you to share the video as I go on short commercial break, wherein I'll take my time to explain all these areas of the law to viewers, and obviously give a little bit of update of the law about immigration and all the changes that are currently taking place. So please don't go away as I go on this short commercial break, which is an opportunity for you to look at what City Law Services to some of the areas of law that we practice. So please don't go away as I go on this short commercial break. for your patience. As I said from the beginning of this show, I'm looking at personal injury tonight. I'll be taking viewers through injuries that occur at the workplace. As I said from the beginning, personal injury is a very broad area of law. It covers motor accidents, those of you who are either passengers or drivers on the road who get involved in accidents, who for some drivers may not even have insurance and they risk complications. Those who perhaps may be knocked down by cars whilst they are on the streets as pedestrians. Those who sustain injuries when they go to the shop floor to do their shopping. For example, one may go to any of these mainstream shops and have an injury on the premises, or even go to an office and have sustain an injury in those premises. And sometimes you go to council buildings, you sustain injuries. So that gives rise to public liability. But tonight I'm looking at employer liability when accidents occur at the workplace, which is employer liability. The employer has a liability to the employee when accidents occurs at the workplace, as long as that accident is not the employee's fault. People should take note of this. It is not every accident that happens at the workplace that entitles employees to financial compensation. I want to set out this premise for people to understand that this is not every accident at the workplace that entitles employee to financial compensation. And that's why most time when you work the TVs and listen to the radios, most of the announcement or advertisement will say that if you ever had accident that was not your fault. That means a lot. So tonight I'm going to look at areas of the law that covers accident at a workplace that is not your fault. So when accident happens at a workplace and it's not your fault, then it gives rise to employer liability, which means that you, the employee or the contractor on that premises, you are entitled to a compensation for your injuries. And when I get to the stage where I'm dealing with compensation, I'll look at the elements of that compensation, the components, all the stuff that you could be entitled to as a result of that accident. So I'm going to look at it gradually from one stage to the other, because this is quite complex area of law. And for that matter, I need to take my time to explain it so that viewers can understand and know their right at the workplace. So to start with, I said that employers have liability to employees at the workplace when accident occurs. So the starting point is that employee who is seeking to make a claim for personal injury at the workplace need to establish that an accident has occurred and that accident is due to the negligence of the employer. And that negligence, which is whatever the employer did, was not too remote from the cause of that accident. So, looking at these terminologies, normally, for example, an employer is supposed to have a safe premises. So if you are working at a place, that place, even by health and safety regulations, need to be safe. If that workplace, the employer does not provide that safe premises, for example, there are wires lying around, there are stuff lying around, there are some electrical gadgets defective, or things lying on the floor and there is no warning, or the floor is slippery, and one for out of no fault of theirs, sustained injuries by either tripping on the floor and sustaining injuries as a result of that premise, which is where that person is working, not being safe, then that is a first ground for one to claim compensation. Because the premise, the surrounding where you are working is not safe. And because it's not safe, due to the floor being slippery, due to stuff lying around, due to the employer not ensuring that he has provided that safe environment for you to work, and because of failure to provide that safe environment, it has caused an accident that has resulted in an injury to your leg, to your eyes, to anything concerning you, then you will be entitled to financial compensation, which I'll go into it quite shortly. But the second ground is for the employer to provide safe machinery. And here, when we talk about machinery, for example, those of you who may be doing scaffolding, those of you who are working in Amazon warehouse, you might have to have some stuff to drive luggages around or pallets around. Or some of you need to have goggles to cover your eyes because of the risk of something falling off and affecting your eyes. Or even having a particular shoe. So the machinery is not just machines that you can, movable machines that you can move them around, but also involves providing gadgets that gives protection to you to avoid accident or injury happening to you. So if the employer feels in their duty to do that and you sustain injury, that means that employer has been negligent for failing to provide that machinery. Some people, for example, may be doing cleaning. I had a client who was complaining bitterly. They might be doing cleaning, they have detergents which are quite pungent, which are quite strong. They've not been given gloves to wear on their hands to protect them from some of these things. And they get contaminated and they get injuries. As long as you can prove that it is because of that failure to provide that gadget to protect you from contamination that has caused that injury, then you will be entitled to financial compensation. So I've looked at the two areas. The third area is providing a competent staff. Now here is so important because when we are looking at a competent staff, we are looking at all the workforce. So if you are working in a place, all the employees that are there have a duty to protect each other from getting injured at the premises. And that employer has a duty to ensure that whoever comes to work, that's why normally when you go to the factory or the warehouses, they take employees through what they call induction and train them on how to use the machinery and what to do when there is fire hazard, and what not to do, and all the things that they can avoid so that they will not cause injury to their fellow employees on the premises. So if, for example, one of the employees was meant to service a machine and he failed to do that, and as a result of that failure, another staff used it and that caused an injury, the employer has no excuse to say that this is not my fault, this is a fault of your fellow employee, therefore I'm not responsible for your injuries. And quite surprisingly, they hear stories where employers may want to make reasonable excuse by relying on the default of another person or another employee at the workplace to excuse themselves of that financial liability by claiming that they are not responsible for that accident, even though it has been caused by a fellow employee. There is what we call in law vicarious liability. What it simply means is that if an employee is acting in the course of his duty by working for that employer, then it means that if he causes an injury to a fellow employee, then even though it is not the employer per se who has caused that injury, but it's a fellow employee who has caused an injury to another employee, that employer is vicariously liable for the injured person's injuries and therefore liable to pay financial compensation. There is a case that came to us recently where the employer has sent an employee to another premises to go and work with fellow employees. And it's obvious that there were quite heavy staffs. There needs to have been descriptions on them, on the weight and all that, and provide machinery and provided support of the employee. And they failed to do that. And this gentleman, out of working hard for the employee, ended up sustaining injuries, because the other employee has not taken note of the fact that he was meant to brief the other employee about the dangers involved in doing that work, which he has been sent to do for the first time. So the other person has been negligent by not advising on what he should do to avoid danger. But our negligence, that employer is vicariously liable for that negligence, and therefore financially liable to pay compensation to the injured and the other injured employee. So that's the third grounds for people who sustain injuries of the workplace to claim financial compensation. And I can go on and on and on and on. But there is one thing that I want viewers to also take note of. This is so important. I have given a precursor or a background to how people can understand their right when they are injured at the workplace, and it's not their fault. I've given that background. But how do you then demonstrate, show that the employer is responsible for the accident or your injuries? Because remember, even though the financial compensation is not paid for by the employer directly, because almost all employers, especially those who are involved in certain tasks, have a condition to have liability insurance, which covers them when accidents happen on their premises, or if it's because of their fault or negligence, someone sustains injuries at the workplace, then that person has a right to claim on their insurance for That's your liability insurance. But the insurance, as we all know, whenever one makes a claim, for example, for motor insurance, if you are involved in an accident and you make a claim, the next moment when you are renewing your insurance, what happens? Your premium goes up because insurance don't like paying, because they are aiming to make profit for both themselves, their employees, and their shareholders and the directors. So most times, many times I've done consumer law here, you find out that whenever there is a claim, insurance companies will try to render out. And in most cases, they try to make it difficult, especially for us lawyers who want to embark on some of these cases for no win, no fee. So in most times, they try to make it quite difficult. But how can people avoid such a challenge or difficulty when they have clearly sustained injuries at the workplace? That it's obvious that those injuries are the fault of the employer because of any of the three reasons that I have already given, in terms of not providing safe premises of work, in terms of not providing competent staff, in terms of not providing good machinery or safe machinery for the work that the employee is conducting on the premises. So what employees need to do whenever they sustain these injuries at the workplace, the first thing they need to do, they need to report it and record it in an accident book. They need to do that immediately, because all employers have a duty under radar to report accidents that happen at the workplace. They need to record it and report it under radar. And I'm sure most of you are familiar with that. Because anytime you have an accident or incident at the workplace, you will bring it, you fill the radar form, and that needs to be filed by the supervisors or the management. So these things needs to be recorded. That record becomes an evidence for you to rely upon if the employer was to deny that there was ever an accident at the workplace. Or if you have injuries, you can take photograph of all those injuries. That's a second way of showing that something has happened at the workplace. These days, we all have smartphones. We can take good pictures. We can send it to friends for them to see that this is what has happened at the workplace. Thirdly, what they can also do is that whenever there is these accidents at the workplace, and they have even done any of these three things, they need to also identify witnesses. If you have a work colleague who saw the accident, you can, or didn't see it, you can make him aware, this is what has happened to me. Or if you have been sent from somewhere to go and work another place, you need to report it to your management that this is what has happened to you. That's the third way of gathering your evidence. The fourth way of gathering your evidence is reporting this accident to your GP. Let it be on record that you have sustained injuries at a workplace. Normally, we have what they call medical notes. Whenever we go to the GP and complain of headache, the GPs make note of that headache. They don't just prescribe medication for us. They make note of it. So if I were to go to my GP and say that, look, today whilst I was coming up with the steps, I tripped and fell. There was a banana peel on the floor. I didn't know that it was there, and I fell and I hit my head and I sustained injuries. Then the GP will record all these things, the time, the date, he will ask note, he will note down when that happened, because he needs to be aware of these facts so that he could competently prescribe medication to treat that injury. So all these will be on record. So if the employer was to deny, then these medical notes will prove that yes, something that happened that you complained to your GP. And for some of you, some of these injuries, you might not even be able to report it. You might not even be able to call a witness. You might not even be able to, for example, record it in the accident book. Why? Because you might even collapse. So for you, you need to take note of the ambulance or the paramedics report that they have made in your favor. And again, some of these documents are easily obtainable. Most times they will give you a receipt of what has been recorded. You need to keep that receipt. That in itself is an evidence of what has happened to you. So these are the various ways that people need to gather their evidence. Because most times, like I said, some of these claims can be quite frustrating and challenging, because the insurance companies are there to frustrate, to make it difficult for these claims to be pursued. And these claims cannot be successful in vacuum. You need corroborative evidence. You need something to show that something has happened at the workplace. So I have looked at the causes of the accidents. I have looked at how you can prove that there has been an accident. Because these two areas are joined together. It is not just about saying that you have been involved in an accident and that innocently entitles you to compensation. But you need to show that it's the employer's fault. And by showing that it's some of these things that I have just explained in terms of calling a witness who testified that yes, this was the fault of that employer because this is what happened, or giving incident report, or reporting it on the radar, or informing the management and making a complaint about it, or making a complaint to your GP when you go for your treatment, and not just keep quiet and pretend as if nothing has happened. And eventually when you want to pursue a claim, you have no evidence to show that indeed accident did occur at the workplace. So having said this, I want this to be quite succinct tonight. I'm going to look at when you have demonstrated all these things, you have shown all these things, what is the time limit and how long will normally these claims take for you to yield fruit to you? And finally, I will look at what is the compensation that you'll be entitled to if you were to be involved in any of these accidents. But before I do that, I want to quickly acknowledge viewers who are here tonight. It's always a privilege to have you guys on board, and therefore I have Ernestina Kakari who is here. Thank you so much, Ernestina. We couldn't finish our conversation today because I was so busy and I couldn't reach back to you. I have Pa Kofi Pizarro, who is also here watching. Thank you so much, Pa Kofi. And I said a good job. I have Danny Boy, who is watching tonight. I have Gmo, who is also watching. I have Michael Palmer Adolfo watching tonight. I have Sophia Song, I hope you are doing very well. I have Beatrice Jamfi, who is also watching tonight. I have Fred Morgan watching, Nana Owusu watching, Mabel Opon Mansa. Mabel, thank you so much for joining us tonight. I have Nana Owusu with Francis watching you live from London, Central London. Wow, Francis, it's been a while. How are you? Let me hear from you. I have Williams Opoku, who is also watching. William, thank you so much for joining us tonight. I have Angelina Hammond watching. I have Ernestina Karika, who said I'm with my family. I have Busy RB, Anchi. I know, Beatrice. I know you are watching. It's a good job. You are the best. God bless you. I have Yeroman, assalamu alaikum. Thank you so much. He said, the boss himself, thank you for your good job. May you live longer, sir. I have Kwakudua, who is also watching Kwakutua. Your face looks so familiar. Cynthia and Koma watching tonight. He said hi. I have Parkwesi, who have a very impressive and operative explanation. Keep up the good work. Okay. Yeah, so thank you guys for being there. Those of you watching from the other platform, I always urge you to join the CITI Media TV rather than watching from my personal profile, because eventually you will need to migrate to that platform. So having said that, I'm now looking at the elements of compensation. I have looked at the causes of the accidents, how the accidents happened, and what people must do to demonstrate that something has happened. Because if they don't do that, then there is a challenge for them to pursue a claim against the employer, even though the employer has a liability for that accident at the workplace. But moving on from there, to start with, there is a time frame within which one can bring a claim, and normally this time frame is 3 years. So people should take note of that. So if there is an accident that happened, let's say 2019 October, we are now in August, that means you have just 2 months, and if you don't make your claim for this accident or this injury, then after October of this year, which is after 3 years, it will be debarred under the Limitation Act 1980, because there has to be a timeline for every claim, and that timeline is 3 years. So people should take notice of this. It's so important that if they have ever been involved in accident, they should ensure that they pursue this claim within these 3 years. In fact, the claim itself take some time, depending whether the insurance company of the employer or the employer have accepted liability. If they do accept the liability, then obviously make it much quicker for one to assess the injuries and eventually get paid that compensation. But if they don't, then these cases can drag on for a while. But for you to have your feet in the door, this claim needs to be made within 3 years. And it's so important that people take notice of this timeline. Now, moving on from there, we're going to look at the elements of the compensation, which legal expert will say the quantum of the compensation. So whenever there is these accidents at the workplace, there are elements of claim or heads of claim that people can claim for those injuries. So the first element is what they will call financial loss. And there are many times that I've had claimants who have called me and said that they had accident at the workplace and the employer has failed to pay them sick pay, and they feel that it's quite unethical, illegal. And I always end up telling them, look, if your contract of employment does not entitle you to company sick pay, then when you are sick, even if it is the employer's fault that you were involved in an accident and therefore have gone sick leave, the employer by law is right not to pay you for that sick leave, because it is not in your contract that you'll be entitled to company sick pay. So under those circumstances, you don't get paid for being sick. So it's not because the employer is doing anything illegal or unethical or immoral. It is the law. However, you have a separate claim, which is you make a claim for accident at work, which is personal injury. Then that money that employer should have paid you for all the days that you were absent from work for sick leave, you will be entitled to that money as a financial loss to you, which is due to the accident that you sustained at the workplace. So I want viewers to take note of that. There are two distinct things here. There is one which is called company sick pay or statutory sick pay. And there is a financial loss which you can only claim it when you make a claim for personal injury. If you don't do that, then you don't get paid. So under this circumstance, you can't blame the employer for not paying you because perhaps your contract of employment does not allow you to claim. But you are quite rightly entitled to what they call financial loss or loss of income as a result of the accident. So that's the first element of the quantum or the compensation for accident claims. The second element is expenses. For example, you are given prescription, you buy it, you are entitled to claim. You take a minicab to go to the hospital for treatment, you are entitled to claim. You take bus to go for physiotherapy, you are entitled to claim. In fact, you employ a cleaner to come and clean your house. It can even be your brother or your sister or your auntie or somebody that lives in the same household with you to cook for you, to clean the house for you. And you are entitled to claim for that expenses because you know why? It's because of that accident. That's why you are unable to cook for yourself. That's why you're unable to clean your house. That's why you're unable to do some house chores. So the employer is liable to pay you for all those expenses that you have incurred as a result of that accident, including your prescription and transportation costs. So that is the second element of the quantum or the financial compensation. But most importantly, the pecuniary loss, or looking at the injury itself, which is the part that is quite substantial. Why? Because there are some workers who get injured at the workplace and they might be 40 years. They have 20 years or 25 years before they get to the pension age. And some of them, they are not able to work again at all. So it means that is going to be part of their financial loss, what they call future financial loss. So I've looked at the past financial loss, which is the lost pay from the sick pay and all that. That's your past. But if your injury, it's said that you couldn't recover permanently and get to your original state of stature or life, and said that you are not able to work for the rest of your life, and that accident might have occurred to you at the age of 40 or 25, or if for example it's 40, then it means that you have future loss of income for 25 years. That's quite substantial. So just imagine if, for example, you are earning 3,000 net pay a month, and here you are for 25 years of your life, you're not going to be able to work again. You multiply this 3,000 by, let's say, every year we have 12 months. So when you do the calculation, you can see that there is quite a substantial amount of money as future loss of income that you're entitled to. So I want viewers to take note of this. We are talking about quite serious stuff here. Or sometimes people might not necessarily be able to work or do the same amount of work if they were working full-time basis. This time around, they are going to work only part-time. So there could be a partial future financial loss. That could also be taken into account, depending on the number of years that you may have to be working on part-time basis before you go on retirement. So that all these will be taken into account as your future loss of income. But more importantly, we also have to look at the injury itself. When you sustain an injury, you go through pain. So one, that pain, the severity of that pain will determine the quantum, partly the quantum or the amount of compensation that you're going to get for that injury. But also the nature of the injury itself. For example, if something happened and your face is cut as a young beautiful lady, probably that will affect your chances of getting married to a handsome man because of the face mark. So when it comes to injury claims, if you sustain injury on your thigh compared to somebody who sustained injury facially on his or her face, even if the injury, the severity of the injury is the same, the amount of money that is considered for the two parts of the body is not the same, because one will deform your beauty and affect your chances of some of the things that I've just mentioned, and the other is in a hidden place that nobody perhaps might see it at all. So apart from the pain that it can cause you, which attracts compensation, financial compensation, the nature of the injury and where that injury occurs also has a different way of considering it. So I have looked at the past financial loss, I have looked at expenses, I have looked at future financial loss, I have also looked at the injury itself and the severity and where that injury sometimes occurs. Hadn't it be amazing for me to have brought to you the Legal Hour Show to teach you your right, so that whenever you have an accident at the workplace, you know what to do. Having said this, this is now the time for me to gradually advertise CITI Law Solicitors. It is CITI Law Solicitors that is proudly sponsoring a program of this nature, reaching across the world, bringing liberty to people, setting captives free. I'm not preaching the Bible, but I know that there is so much law can do to bring freedom to you. I know the joy that some of our clients get when they get to the end of this matter, especially when it's successful for them. So I know that some of these things here that I'm discussing tonight is going to open door for someone and bring joy to somebody's problems. But hey, the firm is the one sponsoring it. So tonight I want to take just a few minutes of your time to explain to you all the areas of law that we do practice. So if, for example, you have a family member who has any of those problems, you know who to talk to. If you yourself have any of these problems, you know where to find us. So that's what I'm going to do tonight. But before I do that, I want to again acknowledge those who have just joined us. I have Rosine Toro. Bonne arrivée, ça va? Merci beaucoup. So I have Rosine Toro who is watching us from here for the director of career care. I have Kwaku Bazaki who is also watching us tonight. I'm sorry if I've not been able to pronounce your name properly, but I'm very excited that you have joined us for the first time. God bless you. And I think I have Kwakudua, whom I've already acknowledged. If there's anybody who is working that I have not acknowledged you, I'd love to acknowledge you. But I can only do that if you make a comment or make a sign. Then I'll be able to do that quite conveniently. But tonight has been an opportunity for us to discuss personal injury law. I said that it's quite broad, but I narrowed it down to just accidents that occurs at the workplace. I didn't look at motor accidents when people are involved in driving offenses where they get involved in accidents, or people who get knocked down on the road. And that's not what I looked at tonight. Tonight I just look at accidents at the workplace, and I look at some of the things that do happen and why employers are vicariously liable for those accidents, or they have liability for those accidents that do occur at the workplace. And look at whether they are provided safe premises for work, safe machinery, competent staff that will not cause injury to their fellow employees, what people should do to gather their evidence, because most times these claims will be rejected or will be defended voraciously, because it's not easy for insurance company to just pay out money to you. They are in to make profit. And some of these things that I'm teaching viewers is a way for them to learn and gather the evidence, so that when the times come, in the times of trouble, you have your ammunitions. Therefore, you'll be able to maneuver your way through successfully and will not be frustrated. So, I'm just going to quickly go through what we do as a firm. Now, this program, as I've said it earlier, is proudly sponsored by CITI Solicitors. If you want to look for us, you can get us at Backing. Our office address is Unit 113 and 122, Backing Enterprise Center, 50 Cambridge Road, Backing, IG11 8FJ. That is our office address. Telephone number is 020 33 55 0782. That's where, if you ever call that number, any given time, somebody will answer. I know that most times, most of you call my mobile. Most times, I'm unable to answer because maybe I'm with a client or one thing or the other. And under those circumstances, I might not be able to answer. But I can assure you, each time you call 020 33 55 0782, please take note of this number. Somebody will answer, and they will deal with your matter. So please take note of this number. Now, I've also put the phone lines on the screen if anybody has any question to ask me, any legal question. I always throw challenge to viewers. If the question is within my jurisdiction of practice and competence, an area of practice, I'll be more than happy to answer that question. It's about making law affordable. It's about giving you opportunity to ask that question that has been lingering in your mind free of charge. This is the only free service you get on this platform. In the office, I charge for consultation. So the phone lines are on there. If you do want to ask a question, it's 0793 293 4518. And it's also on the screen. Or 0744 033 8623. 0744 033 8623. So, the phone lines are there. Having given accurate description of the office address and the number to call if you want to reach out to CITI Law Solicitors, permit me to now explain the areas of law that we specialize in. First specialization, immigration. Now, you will see that we have some of the cases that you can find quite rightly on the platform. There's an anonymity order of it. It doesn't give any indication of who that person is because of the data protection. And that is the wisdom of city law. Whenever we are representing you, we keep your matter private. But you see on the platform the sources that we are bringing to people. My heart weeps when some of you are living here, your children are abroad. I tell you what, from practice, immigration, bringing children from abroad is the most difficult area of this immigration law. Because most times, there is this demon called sole responsibility. And Home Office will find every reason to refuse that application. And we know the number of cases that we have dealt with. And most of you have come onto this platform to give testimony. If you ever have immigration problem, please, we are here to assist you. We'll give you the best of service, and our success rate is quite high. Diligence, truth, and trust. That is our motto for our practice. We'll tell you the truth. If your case has no merit, we will not take your money. We'll tell you the truth. If you have a strong case, we'll fight to the end and ensure that you win that case. So if you ever have any immigration problem, please don't hesitate to contact us. We'll be much willing and capable to assist you. Employment law. We also specialize in employment law. What I've done tonight is personal injury. By employment law, I mean those of you who have been unfairly dismissed from the workplace. You have worked with the employer for more than 2 years. They've dismissed you for very minor offenses. Or you have suffered bullying and harassment. It's a breach of the Equality Act. Or you have been victimized because of your color, your race, or because you have made complaint about something that has been at the workplace. That's what they call victimization. That means they are continuing to pursue you because you've made a complaint about something that happened at the workplace. That's victimization. And above all, if you have been unfavorably treated compared to another person at the workplace whose color is different, whose ethnic background is different, whose cultural background is different, I come here to dissect the law to viewers. I say that discrimination, racial discrimination, it is not just about white and black. It can be between black and black. If one is Caribbean and the other is an African, and one is treated unfairly, unfavorably compared to the other, then that is a discrimination, racial discrimination. Oh, that, go and check the law. It is. There are two black people, but they say racial discrimination. If you look at the Equality Act, Section 9, it's quite clear. It gives clear distinction of the protected characteristics. Culture, race, ethnic. So you might have the same color, but your background might be different. And that could amount to discrimination and a breach of the Equality Act. So if you have been treated unfavorably compared to the other person, or for example, you're being made redundant and you are getting some redundancy pay and you want us to look at it for you, we can assist in all these areas of law. Last 2 weeks, I look at those who have been discriminated from work because of their pregnancy or because of maternity. All these are breaches under Section 18 of the Equality Act 2010. So if you have any employment law, anything happening at employment, anything happening between you and your employer, and you need a lawyer to assist you with that matter, don't hesitate to be in touch. You will not regret it. Our family law department deals with all your non-molestation order, occupation order. If there is a domestic abuse, I always say that these days domestic abuse is a criminal offense under the Domestic Abuse Act 2021. So people should take note. If there is a case against you in the family court, it might not end there. Because once it's established that you have become a perpetrator in breach of the Domestic Abuse Act 2021, that can send you to jail. I have personally represented a client. That perpetrator, as I speak to you now, is languishing in jail. So if you need a lawyer to defend you, if any of those claims have been made against you and you are battling with it, don't take it kindly or lightly, because it will get you into trouble. We'll be here to assist you. If you are going through divorce, oh, yes, it's not a good thing, but it has happened. You need a lawyer to protect your interests. Otherwise, before you find out, all the assets will be dissipated, and there will be nothing there, nothing in the matrimonial pot for you to take away. We will secure that interest for you. Our family law, we are family law accredited. The distinction is that we are not just solicitors. We are the peak of the family law practice. So don't hesitate to contact us if you need any proper advice on family law matters. You know where to find us. Personal injury and clinical injury, that's what I've just discussed tonight, looking at accident at the workplace. If you have any problem within that area, do most of these cases no win, no fee. It's quite slow process. That's why they give 3 years for it to expire. But we'll do most of these cases no win, no fee. And eventually, you will get that compensation that you deserve. Commercial disputes and civil litigation, if there is a dispute between you, if you guys have formed some companies, if somebody is owing you, all these areas of the commercial law, if you want to form a business with someone and you want to put in place partnership agreement or shareholder agreement, director agreement, we can assist you to draft all this. Most of you go into business without putting all these things in place. When the money starts coming, you start fighting and wasting your money in court. You need to make sure that you consult a lawyer well versed in this area to put in place proper system. The law protects your interest and the other party's interest. Without that, there will always be chaos and you end up in court, wasting money and destroying that business that you have served so much to build. Housing law. Now we are in summer, so you don't hear much of disrepair problems. In winter, they are all over the place. If you have a disrepair problem, if you are being evicted and you want us to defend you, we will do that. The consumer law, I come here to bash the insurance companies who have refused to pay your compensation. So that's what we also specialize in consumer law. So I have said so much about city law, and now you know where to find us if you have any of these problems in this area of law that I've just described. However, if you have missed any section or any part of this program, I want to tell you that even when I've left here, it's on the platform. You can watch it again and again and again and learn something from it. Share it with your friends if they need advice on this, because this program is recorded and it stays permanently on the platform. I want to say big thank you to all of you who have been part of this show tonight. I have Gabriel Benkori, we have just joined. Gabriel, thank you so much for joining. So I want to say big thank you to all of you who have been part of this show. It's been amazing having you on board, and I relish the opportunity to always have this interaction with you. I'm so grateful for your loyalty and for your unflinching support to ensure that this program becomes a success. That is why I owe it to you that no matter what I'm doing, I still make it here to have this interaction with you. God bless you. God richly bless you. On Thursday, MC Chaka will be here. We're going to have this show in Tree, among other areas of the law. And again, there's an opportunity for people to ask questions. So please, remember that on Thursday, from 9 p.m., we are going to be here again. So if you miss it tonight, or if you want to enjoy the tree session, that's an opportunity for you to join us. Again, God richly bless you. Bye-bye. God bless you. Bye.